All right, hello everyone. I don't know who's all on this CLE right now, but I'm happy to have everyone. My name is Festeryga, and I'm happy to present Kyle Herbert, who's going to be giving us a discussion on some ethics issues for small and solo practitioners, ethics issues, grievance, segregation of funds, IOLTA accounts, and maybe even a little bit of malpractice if we get into that. This job, being a lawyer, is an interesting and complicated job. Churchill said, lawyers occasionally stumble over the truth, but most of them pick themselves up and hurry off as if nothing had happened. And it's not entirely incorrect, at least from my experience practicing law so far over the course of this last 4 years. We're put in a position of trust, and we have a duty to make sure that we're doing right by our clients. But the substance of that duty, knowing what your obligations are and how to properly satisfy them, that's also a bit of a mystery. And so HYLA and the small and solo committee wanted to put on this CLE to give an opportunity to some people to learn about ethics, client funds, grievances, and how that procedure works if something is to happen. And so we've got here today, and I see a lot of you just jumping on now. You might have missed my intro. And if you did, I can do it again. But this CLE has been recorded. And so you can see it if you missed it, but I gave a small joke about Churchill, or a Churchill quote, and then I kind of worked into some of the issues with the CLE and what Kyle's going to cover. Kyle has been practicing law since, I think, 2003, and has had his own firm since 2008. He's a graduate of University of Texas and South Texas College of Law. He's done just about everything, and he's a bit of an expert on this specific issue and this topic, having served as the serving on the grievance committee from, I think, 2015 through 2019, and was a chair of the State Bar Texas District 4 Grievance Committee from 2017 to 2019. He has some other associations and positions as well. I think he's a board member of the HYLA and was a member of the Board of Advocates from 2012 to 2015 as part of TTLA. So Kyle knows it, Kyle's seen it, and I'm just thankful that he's here to sort of talk to me a little bit about some of these issues and provide some insights and some practical advice to all of us. So Kyle, hopefully that's a decent intro and gives you a little bit of a runway to kind of have this talk, and we can just do a little bit of a Q&A and whatever you feel comfortable with, but we're here to learn from you.
Thanks, Teddy. So I'm just taking a look at the attendees, and I've opened up the chat. I don't know if you folks want to talk or can talk. This is intended to be somewhat interactive. Teddy, I don't know if you can manage this from where you are, but if people want to turn their cameras on, and I guess we've also got a chat function over here on the bottom. So I think if you're having any technical issues or want to log in or submit questions, you can do that through the chat on the right. And then also, I'm not sure how this is being kind of technically managed, but Teddy, if you can do anything on your end.
I'm managing it, Kyle, so you're in trouble.
Yeah, perfect. Okay, well, I hope everyone can hear me. I see 11 participants, so I'll just go ahead and get started. First of all, I thought I would start off by telling you guys, oh, perfect. We can hear you. Fantastic. All right. So I thought I would tell a story about my first encounter with an ethical situation as a lawyer. I have been practicing law for about 5 years, and I had just started my own firm, and I had one partner, and we were doing brief consultations for $100. $100, you could come in and I would chat with you for 15 or 20 minutes. And one of our first guys came in and he had some legal questions, mostly about estate planning. And we finished the consultation and he was supposed to pay me $100. And he reached into his wallet and he handed the bills over, and I took them and put them in my pocket and showed him out. And then I put my hand in my pocket and I looked down, and he had accidentally given me $200 instead of $100. And, you know, I get that first ethical issue, and I have to decide, do I share that $200 with my partner? So I know you're all laughing at home. Don't spit any coffee on your keyboard. It's all going to be this fun and entertaining. I'll also add that this is not officially sanctioned by the State Bar of Texas, and certainly not the Grievance Committee. I served on the Grievance Committee for 6 years. I'm here to give some practical advice. I do not represent the State Bar in any way anymore. And so if you've got complaints about the content or the tone of this speech, you can direct that toward Mr. Festeryga and not to the State Bar, because they will pretend that they don't even know me, and that's just fine. What we're going to talk about today is kind of three big things. One, we're going to go over just some very basics about what's in the ethics rules. Then we're going to go over the ethics grievance process. And then finally, I've got some practical tips for not getting yourself grieved and trying to stay out of trouble with the State Bar. So let me begin by going over briefly what the ethics rules contain and what they're all about. First of all, you should know that the Texas disciplinary rules of professional conduct are not the model rules that we all studied in law school. You took that MPRE exam a few years back, and that had nothing to do with the Texas rules. Those are model rules proposed by the ABA, and a lot of them have been adopted by the state of Texas, but those are not the rules we live by. If you want a copy of the rules, they are easily accessible from the State Bar website. In fact, I think there's a link to them on their front page. So if you've got any issues, you can look them up. They're handy. They're not a secret. They're right there on the internet. Second thing to know about the model rules, the Texas disciplinary rules of professional conduct, is they are not a law. They do not give rise to a cause of action. No one can sue you for your malpractice behavior. They can get you disbarred, but they do not normally give rise to a cause of action. Third, the rules don't really cover sloppy work or bad work or breaches of contract. Those are legal issues that could get you sued, but they are not ethical issues covered by the rules of ethics. So what are the rules? Moses came down from the mountain with 10 rules. The State Bar has seen fit to give us just 16. I'm briefly going to go over these 16 rules. They're really just categories. And then I'm going to give you some broad stroke information about what the rules really contain. Rule 101, you need to be competent and diligent in your representation. What that means is pay attention to the file and don't engage in legal work that is beyond your ability. I don't do lots of things. I don't really do family law. I don't do securities law. I don't do real estate transactions because I don't know nothing about those things. So I do not hold myself out as a lawyer that practices in those areas. And if somebody comes to me with that kind of a problem, I send it to somebody else. Scope and objectives of representation. That's rule 102. 102 really just says, no matter what great ideas your clients come up with, you may not participate in fraud. So if the scope and the objective of the representation gets into criminal stuff, you're not allowed to do that. Rule 103 is communication. You need to keep your clients reasonably apprised of the process that their case is going through. Whether it's criminal or family or personal injury, you got to keep your client informed of what's going on. Rule 104 is fees. You need to not charge an unconscionable fee. I'm not going to say too much about fees because that really varies greatly from practice to practice. Family lawyers charge one way. Criminal lawyers love flat fees. Personal injury lawyers, we bill on a percentage. Other kinds of lawyers bill by the hour. If you have questions about fees, there are a whole bunch of cases that you can look up on the State Bar ethics opinions to give you guidance. Rule 105, Confidentiality, you got to keep your client's business their business. You can't be telling other people about it. Rule 106, 107, 108, and 109 are all about conflicts of interest. Again, that's going to vary greatly from the area of practice, but that's all about making sure you stick to your duty of loyalty. You have to, can't represent people with conflicting needs and desires and goals. Rules 110, 111, 112, and 113 are about some stuff that you're probably never going to come across. They are about how people practice law when they represent organizations, the government, judges, and law clerks. Those are really kind of detail-oriented things that vary based on the branch of government you're working for and all that kind of stuff, and not really pertinent for our discussion today. Rule 114, safekeeping of property. You can't give away your client's stuff. It's pretty obvious. You got to retain their documents. You got to have a document retention policy, and you got to stick to it. And the state bar has rules for that. Rule 116, declining and terminating representation. That explains how the attorney-client relationship is not created and how it's ended if it needs to end. 116, clients with diminished capacity. That explains what you got to do if for some reason you think your client can no longer communicate with you, and that client might need an attorney ad litem or a guardian ad litem to help you sort through those things. So that's it. Those are our 16 areas of rules. But I had them taught to me like this the one night I spent studying for the MPRE almost 20 years ago. And my associate professor who was trying to get us through preparation for this test, he said, look, this stuff is really easy. Give back the money, rat out your friends, and do what Jesus would do. Now, I've actually broken that down into some more practical uses. And there's really just 5 things that I, as a member of the grievance committee, saw over and over. So these are the issues that will actually come up in your day-to-day practice, these 5. Number 1, keep your client reasonably informed of what is going on in their case. You can avoid a huge amount of problems with clients, and the overwhelming majority of complaints I saw while working for the state bar on the grievance committee was lawyers who lacked the time or interest to keep their client informed of what was going on in their case. You don't have to respond the same day. You don't have to respond within the hour, but you got to keep your client up to date of what's going on. I strongly recommend keeping a written record of when those communications with you or with your law firm happen. But that is maybe the single largest complaint we saw at the state bar. 2, get your client's written consent for major decisions. If you are abandoning claims, or certainly if you are settling a case or adding a party that there's been some discussion about adding or not, you might strongly consider getting that stuff in writing by way of a simple email. We saw that plenty of times in front of the state bar. An attorney would abandon a claim, abandon a cause of action, or bring a claim or a cause of action or settle a case without a client agreeing to it. Now, I'll tell you, clients are goofballs, some of them. They forget things. So if you can get that in writing, it's a great idea to do it that way.
Hey, Kyle, as far as getting that in writing, that's just an email or a screenshot of a text message. Any of that will do? Any
of that's just fine. Do not violate your duty of loyalty by signing up too many clients. You might want to represent all the members of that family. You might want to represent all the people that got smashed in that car wreck. State bar rules are pretty detailed about when you get too close to the line and creating a conflict of interest for yourself. Obviously, one of the remedies for that, if you do it, is you end up getting to represent nobody and having to withdraw completely from the case. You might have to disgorge your fee. Lots of other bad stuff can happen if you violate your duty of loyalty by bringing in too many clients on the same matter. So don't do that. Number 4, do not steal from your clients or take money out of the HYLA account that you are not supposed to take. Lots of people get stressed out about this. If you have an accounting error that you got to fix, that's fine. And this seems super dumb, but if you steal your client's money, that is a sure route to being getting a grievance, and that grievance being taken very, very seriously by the state bar. Number 5, if you become aware of a state bar ethics rule violation, you are required to report it, or you have broken an ethics rule. This I did not see come up very often in front of the state bar, but it is an important thing to reminder that you are required to rat out your friends. Those are the 5 big ones that I saw in front of the state bar. Well, really the 4 big ones that I saw in front of the state bar all the time. All right, let's move into a discussion about the complaint process with the state bar.
Hey, Kyle, just before you move on, just curious, but about anything that you perceive to be a violation of the ethical rules, the Texas disciplinary rules of professional conduct. So if you see it, you got to report it. Is there a reporting mechanism? And what are the sort of violations that come up? And I know you didn't see it necessarily, but what are the sorts of things that people would anticipate, or you might anticipate them seeing in their practice that they might need to report?
Well, that's a good question. We saw all kinds of stuff. There is a state bar ethics hotline that I'm going to give you guys in a little bit, and we'll probably try and post to the website. If you become aware of an ethics violation, the easiest way to report it is to simply call the state bar. I have to tell you, in my role as an attorney, the biggest violations that I become aware of, that I feel like I have a positive duty to report about other lawyers in the profession, is usually some sort of substance abuse. I'm not involved in other people's files, right? So I don't necessarily know what's going on between them and their client. But I would say the ethics violation, if you become aware that a person is incapable of practicing law because they have developed a substance abuse problem, there's one thing you absolutely have to do, and that's report them to the state bar. And then another thing that I would encourage you to do, and that is to call TLAP, the Texas Lawyers Assistance Program, which is completely anonymous and helps lawyers get their lives back together when bad stuff happens. But I'm going to talk more about that kind of at the end. And when we talk about some practical tips. So real quick, overview of the complaint process. A complaint process with the state bar, a grievance begins when usually a former client files a complaint. They'll call the state bar, they'll provide a bunch of information, they'll send out an email, and the state bar will assign that case next to an investigator. Then they will send out notice to you and to the complainant, letting everybody know that a complaint has been filed. The investigator will then begin an investigation. Pretty simple stuff. They will go and gather documents. They will interview the complaining party. They will reach out to the other side, who the attorney or the attorney's law firm, and ask if they have any documents or emails or correspondence to review. Typically, what happens next is the state bar might send out a letter encouraging the parties to mediate their dispute. I was never involved with that, so I don't know how effective the mediation process is, but they will encourage the parties to try and mediate their dispute. I can tell you that a lot of these complaints end up being a fight over money, a fee, or percentage interest in a case. And if that happens, typically mediation is very effective because both parties typically understand that going forward can take a significant amount of time, effort, and money to resolve. Once the case goes through the notice and the investigation, and the parties agree or disagree as to whether or not they're going to mediate, the case will then be set for a dismissal docket, or a summary disposition docket. What that does is it is basically a early motion for summary judgment that every case goes through. And the investigator will take his case file, he'll write up a report, he'll send that out to the grievance panel members, and the investigator will typically make a recommendation for just cause or no just cause. If it goes to just cause, the case will continue. If it goes to no just cause, then the case is over. Now, the grievance panel is comprised of a group of lawyers and what are called public members. Public members are just friendly citizens who have agreed to sit on a grievance panel and help out the state bar, kind of just like a grand jury or a petty jury. These folks are, like I said, not lawyers. They're teachers, doctors, insurance agents, just kind of random folks. So the grievance panel will get together. They will review the investigator's docket, and they will make one of three recommendations. Like I said, just cause, no just cause. And on occasion, they will send questions back to the investigator for further investigation. The overwhelming majority of cases are resolved by a no just cause. That typically happens because the state bar has reviewed the file and the panel agrees that either one of two things has happened. Number one, there is just no factual basis to support a finding of an ethics violation, or two, the complainant has completely failed to state a claim. They're complaining about something that has nothing to do with the state bar or has nothing to do with ethics, or the complainant has failed to really provide any information at all and just kind of fallen off the face of the earth. But the majority of complaints against lawyers end up being disposed at this level, and there's a finding of no just cause. Up to this point, you will have, if you've got a grievance against you, you will simply have been sent a notice about the complaint, and you may have provided some information to the investigator, and you might have been interviewed by the investigator and answered some questions, and then they'll let you know when the dismissal docket is, and more than likely you end up getting a little letter in the mail that says your case was dismissed, or that there was a finding of no just cause, and you'll be done. If the case goes forward because the panel has found just cause, you then get to elect what happens to you. You can go through what I call trial by jury or trial by combat, as Rudy Giuliani would say. Trial by jury is just like any other civil case. You get assigned to a district court in your county, and a couple of years from now, you end up going to trial in front of a judge and 12 folks that couldn't get out of jury duty. Or you can elect to have the grievance heard by a grievance panel, who will serve as your judge, jury, and executioner. This is where I would offer some practical advice. You should always, unless there are some crazy extraneous circumstances, choose trial by the state bar grievance panel. It is what I would consider to be a much more fair way to resolve these disputes. The juries remain impartial. We have public members. We're not all just lawyers there to, give lawyers an easy pass. That's not what happens. But juries sometimes do unpredictable things. And I think the process of trial by the grievance panel is much more predictable. So if you end up going to trial by the grievance panel, it's held at the state bar office that's closest to you, and the panel is judge and jury. They will follow, at least loosely follow, the rules of evidence and procedure, just like a court would. And at the end of that trial, they can find, usually the trial lasts a day or two. The most complicated case I ever had went 3 days. But they'll take witnesses, they'll review evidence, they do everything a normal court would do. And then at the end of that, you can win, no grievance. They can impose a penalty. They can impose a private reprimand or a public reprimand. They have pretty broad authority to impose whatever punishment they believe fits the crime. They can make you attend CLE. They can make you pay a fine. They can order you to make restitution. In extreme cases, they will suspend or yank your license. They can make you take the bar exam again. All of those things are stuff you want to avoid. But I would say one of the things that I think the state bar really does quite well is making the punishment fit the crime. So let's say you've got some minor problem and it was really just a miscommunication. You might end up with a private reprimand, and they might encourage you to take some CLE about law office management. If you do something really terrible, well, the penalty will be pretty high. But that's the way the grievance panel resolves trials.
So Kyle, the main takeaway that I'm getting, at least from that bit, is that if you are grieved upon, and should your case proceed down the line to the point that there is a trial, make damn sure that you elect to go with the panel and not a trial by jury, so you don't get 12 people who hate lawyers sitting out there deciding your fate. Is that kind of what you're getting to?
Well, I would put it this way. If you go in front of a panel of lawyers who are committed to the practice enough to serve on the grievance panel, those are folks that have been practicing for a good while. They understand the practice of law. They understand how mistakes get made. They also understand and can figure out pretty quickly those lawyers that are just rats and are screwing their clients. So if you commit malpractice for something other than stealing a pile of money, I would say the grievance committee is comprised of people who understand to a certain extent what you've been through, and are the kind of folks that will craft a punishment, if appropriate, that is appropriate to what you've done. Juries are inherently unpredictable. I have this conversation with clients all the time before trial. You never know what they're going to do. So I find the grievance process through the panel to be much, in my experience, a little bit more fair and a little bit more predictable for everybody, including the complainant. And also, these days with COVID, you might be waiting, have this thing hanging over your head for a couple of years. Whereas the state bar, they're not managing a docket of 1,000 other cases like your typical district court. So they can manage that process much more effectively.
Besides just the stress of having a grievance pending against you, is there any other implication or ramification for being grieved upon?
Well, yeah, there's tons of penalties associated with it. You'll have to report it, put it on your state bar webpage. I'm not sure how many of the folks on here still read the State Bar Journal, but all those grievances and reprimands are there at the back of that magazine for all of your colleagues to see, which can be pretty embarrassing. So, grievance. Pardon? Yeah, it's not good stuff. All right. So here are what I thought I'd do is put together some ways you can absolutely positively get yourself disbarred. So look, let's say you paid off all those student loans, you don't want to practice law anymore, and you are bound and determined to lose your law license because you want to go do something else. All right. Here are a few things you absolutely positively can do to fast track your way out of the practice of law. Steal your client's money and don't give it back, and use suspect accounting procedures for your IOLTA account, and again, refuse to give the money back. I've actually seen this happen in a couple of disbarment proceedings. If you just absolutely want to steal your client's money and absolutely refuse to account to them for it, that is a great way to get yourself disbarred. Okay, next one. And you're not going to believe that this happens, but believe me, it does. If you guys have ever seen that movie, Fatal Attraction, with Glenn Close, where she yells over and over, "Daniel, I will not be ignored." Or if you've seen any of those Taken movies with Liam Neeson, the state bar is a lot like those characters. They will not be ignored. If you get a grievance filed against you, whether it's got some merit or no merit at all, and you absolutely positively want to get disbarred, take that grievance and throw it away and ignore the state bar's repeated attempts to get in touch with you. That will absolutely get you disbarred. And that is a great way to not practice law anymore. Okay, so this is a weird one, but I think it's worth mentioning. If you do something wrong in your practice, you commit malpractice, or you commit a grievable offense, some sort of ethical failure, the cover-up is always way worse than what you actually did. All of the state bar proceedings are confidential, so I will not share any names, but once upon a time, we had a case where a young associate made several mistakes on a file and later committed an ethical violation to attempt to cover up that mistake. The ethical violation was him forging a signature on an agreement to accept service of process. Obviously, the party that had allegedly accepted service of process figured this out and filed a grievance. And in that case, not only did the young associate get grieved, but the managing associate and the managing partner and the founding partner, they all got grieved. It's my guess that had this guy gone in, or guy or gal gone in early, explained his mistake, probably would have been a pretty light reprimand from his bosses, no big deal. But in that case, he took some pretty extraordinary measures to try and cover up his mistake and ended up getting about a half dozen lawyers grieved. And I am fairly certain that guy did not keep his job. So oftentimes when it comes to ethics, same as politics, the cover up is almost always worse than the original mistake. Another one that very rarely ends up getting into the area of disbarment, but I have seen it happen once or twice. We have had lawyers who simply treat the file as though it's their own property, and under no circumstance will they return it. That is the same as stealing your client's property. That file does not belong to you, belongs to the client. And if you absolutely positively want to get yourself reprimanded and get real close to disbarment, just hold on to that file like it belongs to you and never give it back. That's a great way to get yourself in hot water with the state bar.
Hey, Kyle, with many young lawyers moving to a digital model for their practices, I'm sort of curious about, and this kind of relates to the returning the file, but with digital files, how does that work exactly? If you keep a digital file and there really isn't a hard file that's kept, do you have any idea how that works?
Well, just like anything else, you can probably download all that onto a memory stick and give it to them. If you've got originals, you got to give back the originals. Treat this like any other grown-up professional business transaction. Give your client the file in the format that they want it, or give it to them electronically and give them a hard copy. Now, that might not be practical if you've got some, commercial client with offices and offices full of paper. But you got to give your client the file or give them access to the file. Probably they get to decide how they want it. Pretty easy. Okay, another thing that will absolutely positively get you disbarred, and I have seen this one sadly many times. If you wake up tomorrow morning and decide to use all the cocaine in Houston and drink all the scotch in the building, that will get you disbarred. We have an incredibly difficult job. It's right up there with dentists and jet pilots and coal miners by the degree of stress that we put ourselves under. Lots of lawyers make the bad decision to start resorting to abusing drugs, abusing prescription drugs, drinking way too much. And if that becomes a lifestyle habit for you, that can become really problematic. So put some good brakes around you so that doesn't happen, but that is a great way to get yourself disbarred. There are many other ways to get yourself disbarred, but those were kind of the ones that I saw the most often. So I thought we're about 12:35. The Houston Young Lawyers Association tells me that I have to speak till at least 12:46 in order for you guys to get an hour credit. And because this is an ethics discussion, we're going to stick to those rules. I thought I would move down now and chat with you guys, practically speaking, what you ought to do if you get grieved. If a client threatens to file a grievance against you. Okay, so you're working on a file, client calls up out of the blue or sends you an email that says, "Dear young smart associate, I am going to file a grievance against you." This is what you do. You immediately send them an email or a letter or both that contains the following things. Number one, it gives them the State Bar Ethics Hotline. The next sentence under that should say, if you believe I have committed an ethical violation, you should report that immediately to the State Bar and then give them the phone number. The next paragraph, you should explain that you are not aware of any violation, but if they would give you a detailed explanation of what they think happened, you promise that you will look into it. You should then immediately freeze that file and email. Do not dispose of it. Keep it exactly where it is. Do not make any changes to it. And then you should withdraw from that representation. This will immediately let that client know how seriously you take ethics and grievances. And it will also let them know, by giving them the State Bar phone number, that threatening you with a grievance will never work as leverage for them to get you to do something. Almost every time I've seen this happen, either personally or to other people, is a client is dissatisfied, usually about money. And they think that for whatever reason, threatening their lawyer with being reported to the State Bar will immediately make you throw up your hands and do whatever the client wants. Whether you have committed a grievable offense or not, I would encourage you to always take those 4 steps. Provide the State Bar hotline and instruct the client to call it. Tell them that you are not aware of any violation, but you need a detailed description of what they think happened so that you can investigate it. Put a hold on that file and that email, and then withdraw from the case. On occasion, this has happened, I've seen this happen once or twice. You do all 4 of those things, and the client comes back and says, "You were right, I was wrong, I was stressed, sorry about that, don't worry about it." And on rare occasion, you might be able to keep that client relationship and stay in the case, but that is exceedingly rare. Okay, what to do? Oh, here's a question. What's the justification for the withdrawal? Well, I would say the justification for the withdrawal is pretty simple. You now have a conflict of interest with your client. He believes that you are not serving his best interest. I think that that is probably a violation of your ethical duty of loyalty, because the client has let you know that you guys no longer have the same goals involved in whatever litigation you're in. Also, you don't necessarily need justification to withdraw from a case. There's lots of lawyers out there. You're not your client's slave. If the relationship has gotten to the point where a client is threatening you with a grievance, probably best to get out of that trap. Okay, what you should do if opposing counsel threatens you with a grievance. I have seen this happen several times. It is usually exceedingly silly. There is almost never in the course of litigation a reason to report your opposing counsel for an ethical violation, maybe short of committing fraud that you somehow get knowledge of. I can tell you that I have never seen a grievance complaint that was filed by opposing counsel go anywhere with the state bar. I believe, at least when I was on the grievance committee, we kind of looked at those as sour grapes, bad relationship in the course of litigation. And also there are lots of other ways that gets resolved. Number one, there's a judge in these cases. And if you've got a problem with opposing counsel, you're welcome to go and file a motion for sanctions. So in the course of litigation, I'd be very circumspect about filing a complaint about opposing counsel. I would be very circumspect about threatening to do that. I had a lawyer once threaten me to report me to the state bar for doing something that was not an ethical violation by any stretch. But I responded to her with the state bar hotline. And I said, if you're aware of a grievable offense, some lapse in ethics, you must immediately report it to the state bar. And she then said she wasn't going to report it to the state bar. And then I said, look, if I know of an ethical violation that someone else has committed, I have to report them. And so I said, now that you have knowledge of my ethical violation and you've told me you won't report it, I guess I have to report you to the state bar. And that got her real confused and she kind of dropped it. But I thought that was kind of funny. But if opposing counsel does threaten you with a grievance, I would do the same couple of things that I said about clients. Give them the hotline, send them a letter, say, I take this very seriously. I need you to explain to me what you think I've done. And by the way, here's the state bar hotline. Give them a call if you think I've done anything wrong. That usually gets opposing counsel to get down off of that ledge pretty quickly. I wanted to provide you quickly, and I think we can probably attach this to the video. In general, the state bar regulates itself. The Supreme Court and the state bar, they let lawyers basically govern lawyers. And the folks at the state bar and the folks on the grievance committees take that really seriously. But I would also say that the state bar very much understands how difficult the job of an attorney can be. And so to that end, I wanted to share with you three things. One, the state bar has an ethics hotline that is confidential. If you have gotten yourself into a pickle and you don't know how to get out of it, or you are concerned about a course of action that you think might have ethical issues, you can simply call the state bar. It's 1-800-532-3947. That is also literally on the front page of the state bar website. So if you are concerned that some stuff has gone sideways, that you or someone you work with or a client is doing something unethical, and you need guidance, you can call a confidential hotline and get advice. Those people love when you call them. They really, I don't think, get very many phone calls. They're very pleasant and excited to hear from you. So if you've got some intellectual curiosities about getting your ethics all twisted up in a pretzel, give them a call. Throw them some brain busters. Give them something to do. Next number I wanted to share with you is the State Bar Reporting Hotline. That is 1-800-932-1900. That's the phone number you need to provide to your clients. That's the number that you need to use to report unethical behavior. That is the phone call that's the phone call you make when you're concerned about some ethical violation by someone else. Keep that phone number handy. Again, it's literally on the front page of the State Bar website. Finally, and this one, we've had some good jokes and some good times today. And I do want you to take this next portion seriously. There is a group at the State Bar called TLAP, the Texas Lawyers Assistance Program. For whatever reason, lawyers do incredibly boneheaded things. From getting involved, like we talked about previously, to some really harmful substance abuse problems, all the way up to struggling with crippling anxiety, depression, and sometimes that results in self-harm and suicide. I've been practicing now for 18 years. I never thought that I would see a job become so overwhelming that someone would consider taking their life for it. But I have to tell you, I've had several friends and a bunch of acquaintances reach the point that this job was just so stressful that they made terrible decisions, and some of which even ended up taking their own life. And that is a terrible thing that the State Bar absolutely wants to help avoid. And they will go to incredible lengths to help out a lawyer in trouble. The TLAP hotline is 1-800-343-8527. That is a completely confidential phone call. If someone is struggling and you don't want them to know from whence the information came, the State Bar will keep your identity completely secret. And like I said, if someone is willing to accept help, TLAP will go to extreme lengths. They will help get that lawyer into rehab. They will help that lawyer manage his practice while he needs to take time away. They will do nearly anything that they can to help a lawyer get back on his feet or her feet if he or she is willing to accept that help. Having to ask for that help can be deeply embarrassing, but the shame surrounding those issues is really the killer. So do your profession a favor, do your colleagues a favor. If you see somebody's life or practice spiraling out of control and you're concerned for them, make that phone call. Somebody might really thank you for that someday. So keep that handy. I wanted to save 10 minutes or so for questions. I find this really entertaining, so I thought I'd bring it up because it gets added as a proposed addition to the ethics rules. It seems like every 3 or 4 years. So here's the bad news. You may sleep with your clients. I think taste and good manners dictates that you almost never sleep with a client. In fact, I would go so far as to say never sleep with a client. But it is not expressly forbidden by the Texas ethics rules. So if you learn anything today, it's not that. It should be the TLAP hotline. But if you've been practicing law long enough, you know that that comes up almost every 3 or 4 years. Folks want to add that to the rules. And I'm not commenting whether that's a good idea or a bad idea. I'm just saying if you absolutely positively want to sleep with a client, you shouldn't. I wouldn't recommend it, but it's not an ethical violation.
What about opposing counsel, Kyle?
That's probably even a worse idea. That goes back to your duty of loyalty.
All right.
Okay. I have a few minutes for questions. You can add them to the chat. First question is awkward segue. Can I accept cash gifts from clients or bad idea? I would say talk to your CPA. This has actually happened to me. I had a client that owed my firm about $30,000, and he showed up with a check for 20 and 10 in a grocery bag, and he put it on my desk and said, this was just for me. I didn't need to tell my partners about it. I got a pretty good laugh out of that. And so I went ahead and deposited it in the bank account, and I actually took a photo of it so I could document that I'd received payment in cash. And I did, in fact, tell my partners about it. I think accepting cash from clients is not a great idea for a couple of reasons. It's hard to track that stuff by way of HYLA, your trust account. So if your client comes back and demands or asserts that he paid you a different amount than you say you got paid, you got to find a way to document that. That said, I've got lots of friends that do criminal law, and it is not abnormal for them to be paid in cash. The issue that I would have with it, and I don't know that it's an ethical violation, but it could become a problem. What's the difference between a gift and what's the difference between a payment? So I'm not saying, I don't think there's an ethical rule against it, but I would tread real lightly, and I would have some real concerns about accounting to that should you and the client later get sideways with each other about money. What other questions do you guys have about the ethics rules or the ethics process? I want to encourage you, if you get that letter from the state bar that says a grievance has been filed, don't freak out. You should immediately get in touch with the state bar. The worst thing you can do is ignore it. So if that day comes that you do in fact get a grievance, don't run away from it. If you've done something wrong, like I would tell my 8 and 10-year-old, try and fix it. If you haven't done something wrong, you need to be willing to, stand in front of it and take your lumps, and you won't help anybody by ignoring a problem from the state bar. Another question came in. Aside from documenting every deposit withdrawal, what are other good practical tips for HYLA accounting? Well, I, like you guys, went to law school because there was no math in the brochure. I can tell you a couple of things that I've done is, in addition to having a not a full-time CPA, but a nearly full-time bookkeeper, I make the responsibility for every dollar in and out of my firm checking account and firm HYLA account needs to go through a lawyer. It needs to be triple checked and double checked. And I say through a lawyer because I'm highlighting that some people give that responsibility to an office manager or give that responsibility to a paralegal. That is a huge position of trust, handling HYLA funds, and your license is literally in peril if you mess it up. So make sure you don't delegate that responsibility to someone who is not a professional CPA or whose license is not also on the line. Keep that accounting stuff to attorneys and CPAs and nobody else. And then the other issue is I keep photocopies of every check in and out, front and back, for a couple of reasons. One, it makes it easy to go back and there's a paper trail so that I can justify my HYLA balance my IOLTA balance. And two, unfortunately, some clients end up just wanting to scam lawyers. It happens to me about once every couple of years. Somebody tries to deposit a check that's not really from me, or tries to change a number on a check, and having a hard copy of all that, where I know how to go and find it, and I keep it forever, is an important practice to have. And I just attach it to whatever release or whatever document ended that client relationship. Scan it all in, keep a hard copy, never let it go. What should a client do if they feel that their attorneys are overcharging or delaying their trial date purposefully? So that is going to vary wildly, I think, from area of practice to area of practice. Obviously, as a personal injury lawyer, I want to get to trial early and often. So that doesn't really happen. It happens on the other side of the bar, where the majority of my opposing lawyers work for giant insurance companies. And, their business model is to pay as little and as late as possible. So there are ways that I can try and persuade a judge to call me to trial and get around that. However, if I've seen this happen where you've got maybe a family lawyer or a criminal lawyer who's trying to string out the life of a case so that they can extract more fees. Number one, the first thing I would do is go find a new lawyer as quick as possible. Because once you start complaining and threatening to file a grievance, more than likely that relationship is done. And that guy is not going to be your lawyer anymore, and that client's not going to want to be your client anymore. So if you're in a situation where you're being overcharged or there's some sort of intentional delay, I would have a real serious conversation with that lawyer about getting the case back on track and try and get some reasonable goals in writing, so that if the offending lawyer continues on that tack, you might have grounds to maybe file a grievance, maybe get some money back. That said, these days, man, it is getting tougher and tougher to see the inside of a court. I know that maybe the family courts and the criminal courts are a little bit different, but the civil courthouse, it's getting harder and harder in these days of COVID to get a jury in the box. So a lot of things are just delayed just because everything's delayed these days.
Any ethical implications or things that you've seen arise due to COVID, Kyle?
Great question, Teddy. I think, I don't know if it's an ethical issue, but I have seen a lot of really short fuses and a lot of, add to our already stressful job a layer of anxiety because of health issues and trying to manage an office where people are sick or people are wearing masks or people have to take extended leaves because they've been exposed to COVID. I've seen a fair amount of lawyers who I wouldn't normally think of as cranky folks dealing with a whole lot of stress and anxiety. That's not necessarily an ethical issue, but it can certainly turn into one. Can think of a few other kind of minor things. It can be increasingly difficult in an age of Zoom, where almost all of our meetings aren't done face-to-face and in person. That leads to a couple of problems, at least that I've seen in my practice. One of them being is I can't guarantee who is or who is not in a room, right? I can only see so much from that side of the camera. And I've had situations where, the ne'er-do-well cousin or son was in the room, pouring poison into my client's ear, or hearing confidential things that they should not be hearing. I've held depositions where I later found out, or at the end of the deposition found out that, I'm deposing someone and their direct manager is on the other side of the camera coaching them. That's unfortunate that happens. That can give rise to ethical issues. I've also seen some problems where it's much more difficult, especially if there's already a language barrier to communicate via Zoom. And sometimes clients will hear things one way. And because you can't necessarily evaluate their body language or because of some other miscommunication that is made worse by Zoom, that kind of makes it even more important to make sure you're getting important stuff done in writing. So that's some of the issues I've seen. We're right here at 1 o'clock. I'm happy to stay on and answer any questions. I think probably for the sake of the recording, we should probably end the formal presentation. Appreciate y'all's patience. I'm right here in Greenway Plaza. I'm super easy to find. My phone number is 713-987-7100. If you've got any ethics questions, want to bounce something off me, I'm available. I'm happy to take phone calls. My email will probably also end up in the comments at some point. Appreciate y'all's patience. If you've got any bright ideas or questions, how to make the talk better, or if you have ethics questions, please track me down. I'd be happy to chat with you.
Kyle, thank you so much for your time. Kyle's email is in the chat there for anybody who has further questions or wants to get in touch with Kyle. Thank you for the practical advice on an issue that I think a lot of young lawyers in small and solo firms aren't necessarily versed in. And so thank you so much, Kyle. We appreciate your time.
My pleasure. Track me down if you guys have any other brain busters. I'm here.
Thanks, Kyle. Thank you, everyone. I guess we'll just stop recording.